Good afternoon, everybody. I hope you've digested your lunch now and you're ready to hear all about collective dismissals in the UK. I'm Sarah Ball and I'm from Burkitt's. I'm really pleased to be here. Thanks very much, Jose, and everyone else who's organised things. Here's a bit of information about Burkitt's in case you haven't heard of us. We're just in England, 7 offices, and I lead the employment team in London. So I've been asked to speak about collective dismissals and what we do in the UK. I think you're going to have a horrible sense of déjà vu because having just listened to Vincent's speech, there's an awful lot of similarities between the UK and Switzerland. So I will try and go as fast as possible and just nip through all of the main issues that we're going to look at. Generally in the UK, we don't do lots of collective approaches when it comes to employment law. We're normally more focused on the individual. But there are scenarios in which we do look at a collective approach, and one is where there's a larger scale redundancy, and the other is in a 2P situation, but I'm not going to talk about 2P today. So the law says that where an employer is proposing to dismiss as redundant 20 or more employees or an establishment within a period of 90 days or less, the employer shall consult about the dismissals of all persons who are appropriate representatives of any of the employees who may be affected by the proposed dismissals or the measures taken in respect of them. So this sets out when the duty applies, and I'm just going to break down some of this test as we go through this speech, this talk. The first thing to note is as redundant. So the definition of redundancy for the purposes of this legislation is very different from our usual definition of redundancy in the UK. Usually we define a redundancy as a disappearing job, a disappearing workplace or situation where the employer requires fewer employees to carry out work of a particular kind. However, for these purposes, a redundancy just means that it's not related to the individual concerned, or for a number of reasons, all of which are not so related. So whilst this definition includes the traditional concepts of redundancy, it also includes dismissals which are regarded for other purposes as some other substantial reason, i.e. restructuring or the situation where you might be terminating and engaging employees on new terms and conditions. So who are going to be in the 20 or more employees for the purposes of counting how many people you've got? So fixed-term contracts that expire, that are simply going to be terminated at their expiry, are not counted. But it does include voluntary redundancies. So you can't have a negotiation with part of the workforce, ask them to leave on a voluntary basis and then start counting. You have to start counting from the start. And who's affected by the duty to collectively consult? Well, the duty is to inform and consult appropriate representatives of the affected employees. So we're consulting trade union representatives or employee representatives. We don't work on the basis of employee representatives very often in the UK, so there may well not be employee representatives in the workforce, and you may have to go through an election. And in terms of the period of consultation, there are some minimum periods. If you're looking at 20 or more employees being affected, it's a minimum of 30 days. And if it's 100 or more, it's 45 days. And a common misconception is that collective consultation must last for that minimum period. In fact, the minimum period starts at the start of consultation and terminates at the end of the first dismissal taking effect. In practice, though, most employers tend to ensure the consultation does last for at least 30 or 45 days, depending upon which period is applicable in that case. And the obligation is to consult with a view to reaching agreement. So really the process of consultation should last as long as it is appropriate in order to either reach an agreement or to exhaust the possibility of an agreement. The employer has to show that they've genuinely sought to consult with a view to reaching that agreement. And for these purposes, who's the employer and who's the employee? Well, the employer is the person by whom the employee is employed, which seems obvious, but in the context of a group structure, that means the actual employer of the affected employees. So where a parent company proposes a collective redundancy within one of its subsidiary, it's the subsidiary company that has the obligation to carry out the consultation process. And they have that obligation even if the parent company doesn't give them all the information they need. So that can be quite onerous. And an employee is an individual who enters into or works under a contract of employment. There's no statutory definition of an employment contract, so we have common law tests that define who is an employee and who isn't. And in the UK, we have the concepts of self-employed, worker and employee. So it's accepted that this will include employees, and it will even include people who have accepted job offers which are later withdrawn. So if you've made a job offer to someone, they will be included in that number. There are a few categories of excluded employees, but I'm going to skip past those because I don't think they're going to be desperately relevant for most purposes. So the duty applies when you're proposing to dismiss. So what amounts to a proposal? Well, a consultation should begin in good time while the proposals are still at a formative stage. And this case law suggests it should begin promptly once there's a serious risk of redundancy is identified, but before any final decision on redundancies has been made. As proposing to dismiss refers to a state of mind that is much more certain and further along in the decision-making process than mere contemplation. We had a case in the UK where there was a charity that was in very deep financial difficulty in 2014. It's called Keeping Kids Company. And they had applied on the 12th of June 2015 to the government for a grant. And the grant would essentially have seen them rise out of their financial difficulties and be able to continue operating. The government initially agreed, but then when the police started investigating a safeguarding issue at the charity, the government terminated the grant agreement and the charity was closed on the 5th of August. And what the court found was that actually collective consultation should have started on the 12th of June because that's when the charity knew that it was make or break. It either got that grant and it continued or it didn't get that grant and it would not be able to operate. So in order to count your 20 employees, you have to look at who is employed in one establishment. For some employers, that would be obvious. In other situations, employers operate at multiple sites, and it won't necessarily be obvious what constitutes an establishment for these purposes. We had a very famous case in the UK called the Woolworths case, and this was a series of stores, and the employer was arguing that each individual shop constituted an establishment. So when they were making redundancies in several shops, you didn't have to put them all together in one place. And we had guidance from the ECJ, which I think you'll all be very familiar with, but very broadly, they found that each Woolworths shop was a distinct entity, and in order to be an establishment, they had to be a distinct entity, to have a degree of permanence and stability, to be assigned to perform one or more given tasks, and a workforce or technical means and structure to allow tasks to be completed. But it didn't have to have its own independent management or financial autonomy. Now, later on, I'm going to talk a little bit about the Employment Rights Bill, which is the big changes that are coming through in the UK in the next year or so. Anna Birtwistle mentioned this at the start of today, and there's going to be some changes in this area, but I'll come to those a little bit later. So duty to consult. So consultation must include ways of avoiding dismissals, ways of reducing numbers to be dismissed, and mitigating the impact of dismissals. So you might look at outplacement counselling to see if to help people find new work, perhaps some sort of severance pay. And if it all goes horribly wrong as an employer, you fail to follow the correct process, how much is it going to cost you? Well, it's going to cost up to 90 days gross pay, uncapped, per employee. The purpose of this award is to sanction the employer. It is not in any way related to the individual loss suffered by any employee. What the court will look at is the deliberateness of the employer's failure. They will start with the maximum period, the 90 days, and they will only reduce it if they consider that there are mitigating circumstances on the part of the employer. There is the possibility of a special circumstances defence, but it's so rarely capable of being used that I'm not going to go into that. And for a while, it wasn't entirely clear whether, as well as doing a collective consultation, we then needed to do individual consultation. And the answer came in the case of Mugford, which clarified that, yes, absolutely, collective consultation is not a substitute for individual consultation. So you must have an individual consultation process that follows after your collective consultation process. In practice, what you would do is agree with your representatives how you will follow the collective process, and then what will be left to be discussed with individuals as part of the individual process. And we have some non-statutory guidance which can help employers here. ACAS issues lots of different codes of practice, but also guidance, both statutory and non-statutory, and it's very useful for employers to be able to follow that in a whole host of different employee relations scenarios. And I mentioned the Employment Rights Bill earlier, so this has cut an absolute swathe through UK employment law. And one of the things that is changing is that there's going to be a new threshold test. So to recap, employers proposing to make 20 or plus redundancies at one establishment within a period of 90 days must go through a process of collective consultation. What the bill says is that collective consultation will be required if there are either 20 plus redundancies at one establishment or some other threshold test is met, which will involve counting employees across different sites or workforces or workplaces. We don't yet know exactly what this threshold test will be. There will be regulations that will set out, but it could be based on a percentage or it could be based on numbers, and we don't yet know what that will be. We also think that the bill will extend the protective award from 90 days to 180 days, and we're expecting these changes to come into force next year. Again, we don't know exactly when. And just to finish off, I just wanted to talk a little bit about fire and rehire, as we call it. So the scenario where you need to, as an employer, make changes to your employees' contracts, you enter into a consultation hoping to seek their consent to do so. But ultimately, if you're not able to do so, what you might want to have in your back pocket is the ability to terminate all of their contracts and hire them on new contracts. It's sort of the final resort for most employers, and generally employers don't get that far in the UK, and usually they manage to agree a compromise solution with employees. This strategy has been a sort of accepted strategy for a very long time in the UK. Until 2022, P&O, the ferry company, blew this out of the water for us. They went for a really nuclear approach. They fired 800 seafarers and on the basis of this fire and rehire strategy. And it attracted such poor press that the government of the day said, right, we need to do something about this. This is outrageous, 800 people losing their jobs overnight. So what they did was to consult and then bring in a statutory code of practice on dismissal and re-engagement, and that came in last year, July 2024. And really what that did was to bring in a code of a practice that suggests a particular approach that you must take as an employer. You can't make standalone claims under this code, but what you can do is attach this to another claim. So say you're making a claim for unfair dismissal as an employee, you could say, in addition, they failed to follow this code of practice and therefore my damages should be uplifted. So that code set out a step-by-step process. The Labour government said, actually, this isn't enough. We need to do a lot more to stop this process. And they said they were going to bring in some new legislation on this as part of the Employment Rights Bill. We've just recently had this published. So what we know so far is that there's going to be significant limits on the ability to fire and rehire. It will automatically be an unfair dismissal. There is an exception for employers who are in financial difficulties, but it's a very narrow drawn exception. You can only use it where the reason for the variation is to eliminate, prevent, or significantly reduce or significantly mitigate the effect of any financial difficulties. So it can't be used if it's just something that's going to put the company in a slightly better position. What we're anticipating is that it's going to be a case of the company will not be able to survive without going through this process, which is obviously going to be a very high bar. And we think this is going to be enforced next year or the year after. Thanks very much.